Thank you, JP. Good afternoon, Advocate Brauckmann.
Good afternoon, Chief Justice. How
How
are
are
you?
you, sir?
I'm
I'm
very
very
well,
well,
thank you.
thanks, and you?
No, I'm always very well. Thank you, Chief Justice.
Wow. You hold a B.Juris LLB degree,
That is correct, CJ.
and you were an attorney for about 23 years, if my numbers are right.
I think it's 26 years, CJ.
The 20s, I always get numbers wrong, almost always.
Me too, CJ.
And an advocate for about, practicing advocate for about 7 years.
Yes, that's correct, CJ.
And you have acted as a judge.
I've acted as a judge. That's correct, CJ. For a period of according to my calculations, 94 weeks in total, of which 64 was in the criminal courts, including motions, trials, urgents, and 30 weeks criminal court, CJ.
And you are ready.
I'm ready, CJ.
Thank you very much. Colleagues, I just want, before I get your list, just to caution, and the caution extends to all of us, including me and the JP. Let us please remember we still have a number of candidates to interview. We may run into late into the night, 10 o'clock or so, but it can be avoided if you want us to. So let's just test the suitability. May I have the names of colleagues who want to put questions to Advocate Brauckmann, please?
Madonsela.
Schlemmer.
JP?
Thank you, CJ. Good afternoon, Advocate Brauckmann.
Afternoon, JP.
I want you to talk to us about reserved judgments. To date, you have delivered more than 200 judgments, or handed down more than 200 judgments. Am I right?
That's correct, JP.
And how many of these judgments were delayed for more than 3 months?
Nothing. I had no judgment outstanding for longer than 1 month, JP, in all my acting stints. I normally deliver a judgment within a week.
CJ, that will be all. Thank you.
Thank you very much, JP. Premier?
No, thank you very much, CJ. Good afternoon, Advocate.
Good afternoon, Premier. Nice meeting you.
Nice meeting you.
I only
too,
see your
thanks.
photographs.
Okay. Now, do you have any outstanding complaints that you are aware of? And then if you do have, what was the complaint all about? And do you think it does hold?
Do I think?
It does hold. Are the merits?
Are you referring to the Legal Practice Council?
Yes.
And or my bar?
Just the complaints
Yeah, no, I
about
have
your
no
work.
complaints with the Legal Practice Council outstanding. I got a letter of good standing yesterday from the bar. I circulated it to Tebogo. And with my bar, I have no outstanding complaints.
Thank you very much, CJ. That would be all from my side.
Thank you, Miss.
Thanks.
Thank you, Premier. Advocate Madonsela C.
Thank you, Chief Justice, and good afternoon, Advocate Brauckmann.
Good day, Mr. As Commissioner Madonsela. Second time I see you.
Yes, we met in that case, the COVID case,
Yes.
where you made an orders, extraordinary orders concerning cross-border attorneys.
That's correct.
In that case, as I recall, unfortunately, I had the dubious honor to appear for you in that case. You made an order, I say it's an extraordinary order. The first one under the COVID circumstances in which you picked up on the lawyers and said they were not entitled to be in court, and therefore, because of COVID regulations, and therefore they they should forfeit their fees.
That was the order,
The circum-
Commissioner Madonsela.
The circumstances were such that an EFF lawyer, Tami Nongwane SC, had gone to court and argued the matter. You deprived him of the fees from day one, from the time that he consulted with his clients, prepared the papers, and you did not only deprive him of the fees for appearance, you went as far back as him, having taken the matter and prepared for the argument in the matter. How could that be? If the only fault of him was to,
If the only,
if the fault about him was to cross from border to border.
Just
appear.
Chief Justice, with your permission.
JP, let me hear your intervention.
There is an application, no, not application. There is an appeal pending to the full bench of the division in regard to this particular matter. As Brauckmann AJ, as he then was, granted leave to the full bench of the division. So that matter is under, is still going to be considered by the full bench. And I'm not sure the extent to which the questions can be asked, but I'm going to leave it up to the CJ and the members of the commission as to whether or not it is appropriate to ask the candidate on a pending matter.
Yeah, JP, just remind me, by the way, what is the mischief sought to be addressed or arrested by avoiding the discussion of a pending matter that you're not going to be deciding yourself? He has done his part. He has delivered judgment. What problem does the rule or the principle against discussing a pending matter seek to address? What mischief do we seek to avoid? Particularly as it relates to him who is not going to decide the matter.
Well, it might well be that he could be asked about the merits and demerits of the matter, which will be the subject of the appeal. But as I am saying, I'm coming here for the first time. I'm coming here for the first time, and therefore, and that is why I'm saying I would rather leave it up to the hands of the members of the commission.
All right. No, thank you. I think he must answer for his part. He has played his part fully. He's not going to be sitting in that decision, in that matter to decide. Those that have to decide can do so independent of his viewpoint. It's irrelevant. They've got his own viewpoint in the form of a judgment. So I think Advocate Madonsela can ask him to explain himself regarding the propriety of the decision he made or the justice behind it.
Thank you, CJ.
Thank you, Chief Justice.
thank you, Chief
Thank
Justice.
you.
Commissioner Madonsela, I made the order, and let me start with the application for leave to appeal. You appeared on behalf of Advocate Nongwane. The reason why I granted leave to appeal is because I was of the view that in respect of the costs I may have earned, and I said it in the judgment, the reason is contained in the judgment recording the leave to appeal, that I was of the view that another court, there are reasonable prospects that another court would come to a different conclusion on the facts presented to it, and that I might have erred in the order whether it was depriving Mr. Ngongwane of all his fees or just the day's fees. And that is why I granted the leave to appeal. And the instances where I granted leave to appeal while I was acting was limited to matters where I was convinced in law that I was incorrect. I would grant, or where I would feel uncomfortable. And that was mostly where, like you convinced me that day, that there would be, another court would be able to come to a different conclusion, faced with the facts that I was faced that day.
Yes, no, I appreciate, no, judges make judgments all the time and they can be right or wrong. I don't have a problem with that. What I have a problem with is the kind of the order that do you think that you could have. First, let me put it this way. In that case, the issues were that all the lawyers, well, one of the lawyers or two of them, had a license from the LPC to travel during COVID times. You didn't ask for a submissions from the Legal Practice Council on that issue, who had issued the order, the permit to the lawyers. You didn't issue an order calling upon the advocates profession that issued permits to come and give submissions on that part.
I didn't, Mr.
How could it be that you could have just made such a drastic order against lawyers and not limiting it to their appearance on the day when they appear in court, but just take it back to a point in time when they were preparing their case, consulting with their attorneys in their offices, and deprive them of the entire cost of their appearance in the entire matter, not just those of appearance, but everything else? How could that be? Was that appropriate?
No.
Chief Justice, may I please come in with a follow-up on this topic?
Yes, please, Advocate Kane, please go ahead.
Thank you. Good afternoon, Advocate Brauckmann.
Good afternoon.
As I'm sure you are well aware, there are many kinds of proceedings where one may come to a finding on the merits and then have a second part to the proceedings which pertains to the appropriateness of the sanction. For example, in criminal hearings, in labor law proceedings, and so on. And in the second part, where you're dealing with sanction, you would hear the parties on what an appropriate sanction or step should be. You're aware of that?
I'm aware of that, Ms. Kane.
And in this case, to which my learned friend has just referred, you, it seems, did not afford the legal representatives an opportunity to address you on what an appropriate step or sanction would be on your side, consequent on your finding that they had contravened the regulations. Is that correct?
I've already answered that in the affirmative with Mr. Advocate Maronsela, ma'am.
Yes. Did it occur to you that all of the relevant practitioners belong to professional bodies that have disciplinary powers over them? You found that these were criminal offences. Did it occur to you that ordinarily then a criminal sanction would also be available if appropriate?
No, it didn't occur to me, Ms. Kane, because those were for their professional bodies to deal with. I don't have to deal with that.
Well, that is correct, except that you imposed a sanction as opposed to allowing professional bodies and criminal authorities to deal with the matter.
Ms. Kane, I don't agree with you in that regard. It often happens in our court that the basic rules are not complied with, and we often make rule orders depriving practitioners of their costs because they did not comply with it. And in our division, it it often happens because we initially had tremendous challenges with the practitioners approaching the court unprepared. Now, I've already stated, and when Mr. Marunsela or Commissioner Marunsela asked me that, well, let me put it this way, Ms. Kane. When I was confronted with this argument at the hearing of the application for leave to appeal, that is exactly one of the reasons why I granted leave to appeal. I owned up to.
Do you, Chief Justice, may I have one more question? I'm allowed.
Yes,
to,
yes.
I don't want to overstep the mark.
No, it's okay, ma'am. Please go ahead.
Thank you.
Please go.
Thank you. Advocate, do you recognize then that you imposed a sanction without compliance with the Audi Ultram Partem rule?
I do.
Thank you. Thank you, Chief Justice.
Follow up, Chief Justice.
Thank you, Advocate KNSC. Yes, Commissioner Barna.
Thank you, Advocate Brauckmann. The point that is taken about the applications for leave to appeal, but the question is, and it goes to the ability to conduct court proceedings in a constitutional manner. So the question is this: don't you think that the order you made at that time, that drastic order, sends a discouraging signal to practitioners about the right of access to courts in Section 34 of the Constitution?
As it stands now, Mr. Barnard, it may. I've learned a lesson, and I am owning up to that lesson at this stage. And that's why I granted leave to appeal. The portion of the judgment dealing with the I call it the permit case, the permits. As far as that is concerned, I found that I didn't do anything wrong. It was just in as far as that I did not afford some of the practitioners the opportunity to address me on an appropriate sanction. And if that sends a wrong picture to the practitioners out there, I'm sorry about that. But as I state, I learned a very, to call it a humiliating and embarrassing lesson from that.
Well,
if that answers your question, Mr. Barnard.
Thank you. But having said that, my concern is a larger concern than that. It is then, to what extent do you consider applying the Constitution as well in the day-to-day operations of the court? Is this not an indication of a wider problem?
No, no, Mr. Barnard. If you look at my judgment subsequent to that, you'll see that the Constitution was constantly applied. I did not, if you want to say that I'm prone to doing that, that is not correct. That was a once-off during a very exceptional time where I felt that the practitioners were not supposed to be in the court. All of them crossed borders, knowing, or were supposed to know that they were not to be there. And I made a mistake, like a lot of judges makes mistakes, goes on appeal, and it is corrected on appeal. I am not prone to not complying with the Constitution. To the contrary, the Constitution informs everything I do, and since it came into operation, everything I did.
Lastly, then, that was such a big time of confusion at the beginning of the lockdown period that, I mean, there was a confusion as to who should grant permits. At one stage, it was practitioners themselves. At one place, it was the Legal Practice Council. There's such a lot of confusion. And really, one would have thought that in all of that confusion, there would have been a little bit more of a sympathetic approach to litigants who are, after all, not there just on their own behalf, but they're there on behalf of clients that they are representing.
The confusion, if it reigned in practitioners' minds. The regulations were clear, Mr. Barnard. I applied the regulations and the law as it was at that stage. It would be a sorry day if, in circumstances that there are pandemics or confusion, for us, the judges and whoever is involved, to decide not to apply the law. There was a reason why those regulations were made. There was a very good reason for people not crossing boundaries without the permits. At that stage, nobody could cross any boundary, not a judge, not a practitioner, nobody could cross boundaries, and it was clear. And the regulations were also clear at that stage, Mr. Barnard.
Thank you, Chief Justice. Thank you, Advocate.
Thank you, Mr. Barnard.
Thank you very much, Commissioner Barnard. Prof.
I'm covered. Thank you, CJ.
Thank you. Thank you very much, Advocate Brauckmann. Your excuse.
Thank you, CJ. Thank you, Commissioners.